Good evening. This is Making the Case. I'm Yodit Tewolde. After a second day of deliberations, we're still waiting for a verdict from jurors in Kim Potter's manslaughter trial. But just a few hours ago, we got an indication of where things may be headed. The jurors deciding the fate of the former Minnesota police officer charged with killing Daunte Wright asked two questions. One was a request to examine Potter's firearm. The other was a question about what the jury should do if they can't come to a consensus on a verdict. Here with me tonight are two legal experts who've been following this case closely. Paul Henderson, a veteran prosecutor and BNC legal contributor, and Rick Petry, a criminal defense attorney. All right, guys, so after deliberating just over 9 hours today, the jury was released, but not before they sent the court two questions. Here's Judge Chu reading the first of two questions asked by the jury this afternoon.
If the jury cannot reach consensus, what is the guidance around how long and what steps should be taken? And the answer is, I'm going to reread to you an instruction that I previously gave you. You should discuss the case with one another and deliberate with a view toward reaching agreement if you can do so without violating your individual judgment. You should decide the case for yourself, but only after you have discussed the case with your fellow jurors and have carefully considered their views. You should not hesitate to re-examine your views and change your opinion if you become convinced they are erroneous. But you should not surrender your honest opinion simply because other jurors disagree or merely to reach a verdict.
All right, Rick, you predicted we'd be here where the jury can't come to a decision, so them asking the court for some guidance on the issue isn't surprising for you, correct?
No, not at all. Not at all. They've only had 2 days to deliberate. I think that there's a lot of confusion looking at the closing arguments and the rebuttal. So it doesn't surprise me at all that they're where they are now. I wouldn't say that they're stuck yet. I'm not concerned about a mistrial from a hung jury yet, but I'm not surprised that they're where they are.
Paul, we don't know if they're stuck, or I'm using the word stuck on one or both charges, or what the divide is.
Well, we don't know, but I gotta say that those questions, at least from the prosecution perspective, are not good. That is what you hate to hear when one of the questions is, what do we do if we can't decide? That means that they're at least having serious conversations that have to be brought out and articulated to the court about not deciding on something. And that's never good for the prosecution, especially coming right after they've concluded their case. Now, I know we're reading the tea leaves, but I would bet that the issue is trying to interpret the emotional response towards defining what a mistake is. And that means that what prosecution is feeling like they probably should have spent a little more time articulating about how mistakes can be culpable, how mistakes can be either reckless or negligent, and when they are, that there's criminal accountability for those things. I mean, I think like the response is if they get a chance to speak, which of course they will not, they should have gone back or tried to lay down a little more heavily the lead up to the mistake happening. The intentional actions that translated into violations of risk, violations of warnings, violations of trainings that led up to the mistake that was subjective. It's a subjective mistake. It doesn't mean that it wasn't a mistake. Trying to connect that mistake to criminal liability is, I bet you that's what the issue is. Those tiers worked.
Well, they also asked, oh, most certainly. I mean, the emotional testimony from Kim Potter most certainly is what they're also factoring in. We know this, and they shouldn't, but they're human. They also asked another question, and let's watch Judge Chu here again reading that question.
Your second question was, can the zip ties be removed from Exhibit 199, Potter's gun, so that it can be held out of the evidence box? And the answer is yes.
The defense objected to the judge rereading the questions in the courtroom, which was overruled, and then the jury was, dismissed back to the deliberations room. Why do you think, Rick, that the defense objected to the judge reading these questions in open court, which is a common way of handling them?
Yeah, I have no idea. I mean, a lot of their strategies haven't. I sort of get it, like they're trying to cause as much confusion, which I think could cause doubt as possible. But this is common. I mean, it's a standard operating procedure that if there are questions that they would be read in open court, you'd bring the jury in, and the judge would answer the questions or not, sort of like we saw the other day. So I have no idea what this is all about from their perspective.
Paul, the jurors weren't allowed to hold the firearm when it was first introduced by the prosecution during their case in chief, but the judge said that she would allow them to examine the gun during deliberations. That question, along with the question about not being able to come to an agreement, tells us at least one thing, that the jury is trying, right?
Exactly. And this is not an uncommon thing. Frequently, when you have a gun case or you have a case involving a weapon, the jury wants to know as much about that weapon as possible. And it is standard not to give them that weapon so it's just in there while they're deliberating. But in this case in particular, where so much has been made throughout the trial on the differences and distinction between both the gun and the taser, I think it's inevitable, and I halfway expected the jury to go out of their way to demand to at least see one, if not both, of those weapons in order to contemplate what the differences are and understanding the differences between both of them as a weapon. And again, I think this is an opportunity for me to say that if, as a police officer, you cannot understand the difference and distinction between either your firearm and a taser, then you should not have either of them. But that will be for the jury to decide in this case, and they'll have that at their disposal. Obviously, it won't have bullets, it won't be live, it will be disarmed, but they'll be able to look at least one to understand and probably weigh in their minds as to whether or not this was a credible mistake or not. Again, I think that's somewhat of a rabbit hole. The issue is not whether or not this is a mistake. The issue is, does the mistake rise to the level of a mistake that was either reckless or negligent? And if so, then there should be criminal liability. But their interpretation and review of the weapon may hinge on that. And so the judge is giving it to them to see if it helps them make a decision.
Now, one of the interesting observations made by a Minneapolis TV station who reported from the pool reporter, the observation of the jury as they returned to court with their questions. The reporter said the jurors were, quote, quiet and calm, not visibly emotive, frustrated, or angry. They appear neither tired nor energetic, just relaxed. Rick, when a jury is deadlocked, the judge can direct them back to deliberate further, usually no more than once or twice, before calling a mistrial. Can their demeanor play a factor on how many times it feels appropriate for the judge to send them back?
Oh yeah, absolutely. If they're calm and relaxed, then I would say they are just going through, for lack of a better term, their deliberations or their due diligence. They're working their way through this case. There's a lot of evidence. There's a lot of confusion that was raised by the defense. For example, for them to ask some of the questions, and I heard another reporter say that one of the jurors was feverishly taking down notes when the judge was reading the jury instruction. Well, they have copies of the jury instructions. So I just think that they're working their way through this. Again, I'm not yet concerned that they will come to the point where they say we just cannot get to a unanimous verdict. I think they're just working their way through it. Now, having said that, as we get closer to Christmas Eve and Christmas, Friday and Saturday, I think those dynamics will change. And if they come back, or perhaps even outside the jury room, the tone may change. You may hear people starting to yell at each other. They get frustrated. They want to go home. They've had enough of this. Then I think we're in a different position, but not yet.
This is the second jury that's had to decide a case before the holidays, so I definitely think that they're feeling the pressure. They will be feeling the pressure if they haven't already. All right, we'll talk more about today's trial developments with my panel after this quick break. Jurors debating the fate of former officer Kim Potter asked 2 questions of the judge today before ending their second day of deliberations. One question, to take the gun Potter used out of the evidence box. The other, guidance from the court if the jury can't reach a consensus. Back with me, veteran prosecutor and BNC's legal contributor Paul Henderson and criminal defense attorney Rick Petry. All right, guys, let's talk specifically about the charges. Potter is charged with first and second degree manslaughter. Paul, we've heard the defense call this an accident. We've heard the prosecution say that accidents happen all the time, but that doesn't mean that they can't be criminal. Can you explain for our viewers the difference between the 2 charges, one that involves recklessness and the other that involves culpable negligence, please?
Yeah, well, there's a higher risk associated with behavior that is reckless. So, say, for example, you decide to get in your car and you drive drunk and you've been drinking and you get into an accident. That's oftentimes where you see charges that are like this, where it's a negligent homicide. And you have to evaluate the legal standards to understand what culpability rises from actual accidents, actual mistakes, because there can be liability for accidents and mistakes. And this is one of those instances. And when you have taken steps where you have, for this case, as you have ignored risks or have not maintained your training, or you did not follow the warnings that were associated with your weapon, and then you have a mistake, that mistake can be culpable. Let's keep in mind that someone is actually dead. And there's a different standard of care when you're engaging in the use and regular use of lethal firearms, which is what we're talking about when we're talking about law enforcement in general. So it's somewhat of a complicated stretch or an understanding to explain to a jury that mistakes can make you liable, that accidents can make you liable, but this is one of those circumstances, and you need to explain it in that way so that people, a lay audience, can understand the law and how it can be applied to both mistakes and accidents to make someone liable. That's basically what prosecution's job has been, and that's being overshadowed, I believe, or a distraction, I believe, for this jury by the emotional testimony and the tears, which are a distraction, and go to defining the mistake or the accident rather than applying it towards whether or not the accident or the mistake itself should be applied independently to understand culpability, to justify or not justify the actions against Daunte Wright in this case, the victim.
Well, let's talk about sentencing. We may not get to that point, but it's important that we at least touch on it. If Potter is convicted of first-degree manslaughter, the maximum sentence is up to 15 years. For second degree, it's up to 10. Now, Potter doesn't have any previous convictions, so we know, that is actually in favor for her. Rick, do you think that juries consider prison time, even though they shouldn't during the deliberations, but that could keep them from convicting this very sympathetic witness and defendant?
Yeah, I'm really glad you asked that question, because one of the things that so the short answer to your question is yes, I think that that's something that they can be considering. And I think it could also weigh very heavily in their deliberations. What I've been hearing in the community is a lot of people saying, yeah, but she didn't do what Derek Chauvin did. She just made a mistake. And, yeah, she should probably get into some sort of trouble, but not this much trouble. So, those types of considerations, I think, are what arise when you have a defendant like this that cried and was very emotional. And I think that wasn't in the courtroom, obviously, but I wouldn't be surprised if those jurors were impacted by that emotional outburst. The other thing, speaking of sentencing, is this notion that she said, "I'm sorry." That typically goes to sentencing, right? If there's some remorse, that's a sentencing consideration more so than consideration as to whether you're guilty or not. For example, you could intentionally kill someone and be sorry after the fact. That doesn't mean that you're not guilty of the crime. It just means that you're sorry that you committed the crime. So I think that there's probably a little bit of confusion in the jury room, or at least some consideration being given to that as well.
Not to mention, they are probably aware that her husband and 2 sons are in court with her. versus Chauvin, who didn't have anybody in the gallery to support him as well. So I'm sure that that is playing a factor as well. All right, guys, final predictions from you both. The judge has said that the jury can take through Thursday to deliberate before taking a break for Christmas. Do you think we get a decision before the holiday? And if so, what is it? Paul?
All right. Well, like I said, those questions today were not good indicators for guilt or for the prosecution, but I'll take solace in the fact that they weren't looking upset and seemed calm about saying that they may not have reached a verdict. They still have plenty of time to get to a verdict. I suspect that they will get to a verdict before Christmas just because they're tired of talking about it. I'm hoping that they get through and understand the issues of guilt and the liability from the mistake. So I'm going to slightly bet on them coming back with guilty. I wish that they had the opportunity to address, as we have, some of the deeper conversations about race disparate treatment from these mistakes and how the outcome for communities of color in terms of lethal force with police officers is different. And I think it does apply in this case, even though they can't bring that into the trial itself, because it's not fact specific to just this case alone. And it's looking at the aggregate. But I do think it's really important that we understand as an audience and viewers about how the subjective decisions that escalated this encounter is affected by race and resulted in mistakes like this, where someone can and should be held accountable. That's the outcome that I'm looking for.
Rick?
Yeah, I think Paul raises some good issues. I'm going to predict that we get either a verdict, which may be a compromise verdict, not to the top count, but perhaps to the lower count, or that we wind up with a hung jury, by the end of the day on Thursday. And keep in mind, they only have to have one person holding out one way or the other for us to wind up in that situation. I think it's also important to take into consideration the makeup of this jury. This is a totally different jury demographically than what we saw in the Chauvin matter. This jury is predominantly white. I think it's a typical jury that you would see in Hennepin County based on all my years of experience. So that's my prediction.
All right, guys. Well, we'll see what they come back with. I definitely think they will be splitting the baby as well. Rick Petry, Paul Henderson, thank you so much for your insight tonight.